Right. Well, I am Hubert Santer from JC Group, Sofia. So I'm here, just muting this. I am here as part of the Think NEXUS NGI CSA project, and actually today we'll be introducing this session focusing on transatlantic crossings, the future of EU-US data flows. So thank you first to everyone for attending this session, and especially to Hans Graux and, well, I hope very soon Dan Caprio to be both our speakers for this session. As you may know, Think NEXUS is a project focusing forcibly on EU-US cooperation in the field of next-generation internet. So, as you might guess, this session focusing on the privacy shield and data flows is, well, very much in these kind of considerations. Quite obviously, the transfer of data, the fuel of internet and everything that is related to that is a very important matter for us and for everyone. So just Fabrice, if you can go one slide further, I think you're sharing a screen and everyone can see your screen. So if you can go a bit next. Yeah, so we're introducing that, and then we will let Mr. Graux presenting a bit what happened, what was the privacy shield, what is going on, and hopefully what is the nice and bright future that will come and replace the privacy shield, let's say, framework. Dan Caprio from Providence group, so he's in DC, by the way, so Dan is one of the Think NEXUS experts, will introduce his view and more generally the view of the US civil society on this matter. And then we'll leave hopefully about 10 to 15 minutes just for questions and extending on these different considerations. But before that, just a couple of words on the privacy shield status and what was happening. So if you may see the text on this slide, a very quick introduction about this privacy shield. So the privacy shield is a framework that started, let's say, in 2016. This framework enables data protection on data that are crossing the Atlantic. So basically providing data protection obligations on companies receiving personal data. Safeguarding also US government access to data, because as you know, in the EU, and I think it was already mentioned a couple of times, we've got this regulation linked to personal data protection, namely the GDPR and everything that is linked to this. And in the US, there is not. There are a lot of ongoing, let's say, frameworks that enable data exchange across the ocean, but also within the US territories, which is way different of the EU approach. The privacy shield framework also enabled an effective protection and redress for individuals. So basically contacting the authorities with regard to any question on personal data across the ocean. And this privacy shield framework, again, provided, let's say, a space for EU and US stakeholders, officials, to exchange about these data exchanges and how to, let's say, develop the framework and every policy into this. So very shortly said, since July 2020, through the Maximilian Schrems case, this privacy shield is down and is not anymore, let's say, able to protect the exchanges of data between the EU and the US as it was. There are still, of course, contractual clauses, I mean, the standard contractual clauses of transfer of personal data enabled, let's say, between both areas, but there is not anymore this specific framework that enabled more thorough, let's say, cooperation between both areas, and all the official stakeholders on the EU side, the European Board on privacy and data protection, for example. I mean, there are many organs working on it. They are all working on the next steps associated to this important issue, as you can guess, for NDI technologies, but every, let's say, commercial aspect between both areas, as well as research-related cooperation and innovation, and everything linked to this very important axis of development between both areas. So, Fabrice, if you can go next slide. Fortunately, there are people today that are way better than me to explain all of the challenges and consequences of this context. Namely, Mr. Graux, Hans Graux, who's attorney at law and partner at Timelex. And by the way, I noted you were also a lecturer on ICT and privacy protection at the Tilburg Institute for Law. So Hans, you will of course introduce yourself just a few words before you go. So you supported a lot of companies, governments in many issues related to electronic identification, trust, on cloud computing, information security. So you will be our best asset to present the EU view on this specific topic of privacy shield. And after that, should he manage to come to this platform, so Fabrice, if you can go next slide, there will be Dan Caprio. So Dan, who's co-founder and executive chairman at the Providence group. So basically a civil society group based in DC, Washington, DC, in the US. So Dan served as Chief Privacy Officer and Deputy Assistant Secretary at the Commerce Department. And he also advised a couple of committees, namely in the OECD, but also at the US FTC organs, in order to develop, let's say, policy responses to the challenge that are linked to data privacy, cybersecurity, and so on. So, Mr. Graux, floor is yours, and yeah, please go for tackling this very interesting, say, issue and challenges that are due to this legal event of the privacy shield downfall. Please, Hans.
Thank you very much for the kind introduction. Yeah, we certainly have plenty of challenges, so that will not be a problem, unfortunately. So yes, good afternoon, everybody. So indeed, my name is Hans Graux. I'm a lawyer with a law firm called Timelex, which specializes in data protection law, ICT law issues in general. Beyond that, I'm also a lecturer, a part-time lecturer at a few universities, and also president from a regional data protection authority in Belgium that supervises data protection compliance with public administration. So we get an overview of the importance of transatlantic data exchanges from a lot of perspectives. I could speak on this topic for hours, but I'll try not to. I'll try to start off with a quick summary of why the privacy shield was so important, what went wrong, and then also discussing some potential next steps to see how we could plug the gap. So I think that the history of the privacy shield has been more or less covered. The crux of the issue is, as most of you will be aware, that the European Union prides itself of having relatively strict data protection legislation. To make sure that that legislation is effective in practice, we have rules on transferring personal data outside of the European Union. Basically, we want to make sure that when personal data is sent to another jurisdiction, the level of legal protections don't become lessened for European citizens. The European legislation, General Data Protection Regulation, has a number of mechanisms for doing that, a number of ways that allow you to more easily exchange personal data to destinations outside of the European Union. Main instruments that people are aware of are the adequacy decisions, where some countries are found to have essentially equivalent legislation to the European Union. So where the European Union basically says, you can treat this as part of the European Union. It's part of the family. We have the same data protection perspective, same data protection principles as within the European Union. So your data is equally safe or equally unsafe as it is within the European Union. Apart from that, we have standard contractual clauses, contractual safeguards that you are allowed to apply to certain partners. And beyond those, there has been, for a very long time, for almost 2 decades now, I would actually call it sort of a privileged relationship between the European Union and the United States. This is, I think, that's kind of a small thing that I want to emphasize because it's important for where we're going in the next couple of years. I'll pick up on some of the questions as I go on as well. The past 20 years, past 30 years, we've seen an incredible globalization of ICT infrastructure. Data flows and free flow of data has been very important, both for the European economy and for the United States economy. And therefore, it was also seen as important to be able to exchange data between the United States and between the European Union pretty easily. Now, obviously, what Europeans would have loved to have seen is for basically the United States to get a positive adequacy decision, a finding that the United States has basically equivalent data protection legislation as Europe. However, the philosophy of data protection law is different between Europe and the United States. Europeans like to pretend that the United States doesn't have solid data protection law, but that's actually an oversimplification. The main distinction is that data protection law is a little bit spottier, I would say, in the United States. Starting getting some echo. Can people mute the microphones, please, if they're not talking?
Dan, sorry, if you can mute. I don't know if you're already muted for the time being. And yeah, thank you very much. And
I'll continue. So the data protection legislation in the United States is a bit more spotty. If you look, for instance, at the legal framework for health records, for patient records, legislation in the United States is a lot more demanding than in most European countries. So the perception that the United States, any perception that the United States doesn't have data protection legislation is not correct. However, the coverage is not as horizontal, and therefore the adequacy decision for the United States would not be feasible. To resolve that issue, to stop us from having to use contractual clauses in every circumstance, the United States has had 2 subsequent sort of exception regimes. First of all, the safe harbor arrangement, followed by the privacy shield, which basically companies could sign up to. Essentially, you can think of that as a self-certification mechanism where companies say, I will agree to adhere to European data protection principles, while the United States as a whole might not be covered by the same universal data protection law as the European Union. I will respect the principles of European data protection law, and therefore I can be considered an acceptable partner to do business with and to exchange information between Europe and the United States. So that's sort of an exceptional regime. The United States was the only country that had this kind of specific status where companies could essentially self-certify their compliance with data protection law. And that was very important for major ICT providers, of which obviously the United States has very, very many. The Schrems case was very relevant there because, as you'll also all be aware, there were some doubts on the effectiveness of this regime. Basically, the question whether certain legislation in the United States, particularly national security legislation in the United States, did not hollow out the effectiveness of European legal protections. Max Schrems went to the European Court of Justice, basically arguing first that the safe harbor regime was inadequate and did not satisfy the requirements of European data protection law. He was successful. The safe harbor regime was invalidated and replaced by the privacy shield, which had greater protections, greater safeguards for European citizens. However, Max Schrems attacked that regime as well, arguing that it still was not sufficient to provide legal guarantees, legal safety for European citizens' data. And as you all have understood, the Court of Justice ruled in his favor again. So the privacy shield has also been invalidated. That basically puts the United States on equal footing with any other country that doesn't have a positive adequacy finding, meaning that you can still use data transfer mechanisms that are available for other countries as well, notably standard contractual clauses, also binding corporate rules and some other mechanisms. Well, I won't go into all of the details. That's quite inconvenient in practice. First of all, because using standard contractual clauses implies some administrative overhead. It means you have to check in each specific case that these clauses, that this annex, basically a package of, on average, probably around 15 pages of contractual documents, is signed as well. Details need to be sorted out. So administrative overhead, that's annoying. But also part of the discussions for the European Court of Justice was also whether these contractual safeguards were actually adequate to justify exchanges between the United States and Europe. And there's where the really tricky part came in. The Court of Justice said that it would not invalidate the standard contractual clauses as such. So it is still possible for European companies to sign these contracts with service providers in the United States, with partners in the United States, in order to exchange information. However, the Court of Justice also said that, well, if we want to be at all objective or reasonable about this, we have to acknowledge that the same doubts on the effectiveness of the privacy shield, those same doubts also apply to contractual safeguards. So the extensive powers that United States national security authorities have under FISA legislation, under the Cloud Act in the United States, under Executive Order 12333 off the top of my head, which allow them to seize data pertaining to European citizens, that also applies to standard contractual clauses. That problem does not go away. So where we are right now is a situation where if you want to exchange personal data with partners in the United States, you can still do that on the basis of standard contractual clauses, no longer on the basis of the privacy shield. That's been invalidated. But the European Court of Justice has some very stringent, very demanding requirements for you if you want to do that as a European exporter. Essentially, it requires you to conduct an assessment yourself. It has not done that for you. It will not do that for you. It requires you to do an assessment for yourself to see if your particular circumstances, taking into account all the details of your data processing activities, the scope, the scale of the data, its sensitivity, the likelihood that it would be targeted, whether under those circumstances it is still feasible, it's still justifiable to transfer data to the United States, and whether the guarantees that you have are adequate to protect personal data. That's quite a heavy burden. So that's where we are right now. Legally complicated situation. It's not going to get solved until we get a bigger political agreement, Privacy Shield number 2 or Safe Harbor number 3, no matter how you want to call it, or a broader agreement that streamlines the relationship again between Europe and the United States. But I also want to point out that there is a bigger policy context to this. This is, Europeans have been, depending on your perspective, we've been praised for having strict and innovative and effective data protection law. We've also been criticized equally rightly for exporting our perceptions and our expectations of privacy to other countries who might have perfectly valid reasons to not make the choices that we have made within Europe. What we're seeing today, and I want to kind of step outside of that discussion on Privacy Shield and data transfers, what we're seeing today is what I would really call a crisis in the belief of globalization of data flows, and basically a resurgence of the belief in the importance of data sovereignty. More and more countries, not just within the European Union, but outside of the European Union as well, have become convinced that their data is such a strategically important asset that they cannot run the risk anymore of foreign authorities, foreign countries exercising control over that in practice. Obviously, the Schrems case is a manifestation of that within the European Union. The discussions that you have in the United States around TikTok being required to be sold to a US company is essentially exactly the same thing. That's basically the United States government saying that this particular set of data is potentially valuable, important from a policy perspective, and we need to make sure that it stays, when it relates to the American citizens, that it stays in American hands. We've even had suggestions, press releases last week of the European Commission examining possibilities of doing the same thing for Facebook, requiring Facebook to sell its European activities to a European company in order to shield that data, basically dividing data back into silos again. I personally find that a worrisome trend because it goes contrary against everything that we've been building on for the last 20 or 30 years. Arguably, maybe we're now going to be smarter about it, and then we're going to come up with more innovative solutions. But that is the Schrems 2 case is important in isolation, but I would encourage everybody to think about it as a symptom of a bigger issue, the bigger question of how strategically important is data and how far can you trust other parties to keep their hands off your data, which is essentially the fundamental question. And yeah, within the European Union, we've so far had a very EU-centric approach on that. I'll pick on two of the questions that have been raised in the chat because they're kind of related, and then I'll wrap up. So we've always had this perception within the European Union that we have the right perspective on data protection law and privacy and on fundamental safeguards for data protection. And we feel that if we want to freely exchange information, the adequacy of foreign data protection law has to be assessed as well. In practice, that's done by the European Commission. So they launch a study where they examine all the characteristics of data protection law in another country. So they look at whether there is legislation, how effective it is, are the safeguards comparable to what we have for European citizens, but also whether the court system is fully independent, whether judges are indeed free and it's possible for them to enforce the law, and to make sure that that legislation is effective. So it's not just about copy-pasting data protection law, but it's actually about looking whether it's effective in practice. So it's the European Commission that does that assessment. It's a very long, arduous process. Recently, the one from Japan has been completed. I think the one from South Korea now as well. It takes a long time, it takes a couple of years. The other question that has been raised is national security. Why all of a sudden do we have to be concerned about that? That's not a European competence. That is obviously true. The European Union would not be able to regulate what even EU member states are allowed to do in terms of national security. However, it is allowed to regulate which data transfers are legitimate, and the national security rules in other countries are part of the package that's considered when determining whether effective safeguards, adequate protection mechanisms exist in other countries. It does lead to some consistency challenges because, well, as most of you will be aware, even European member states occasionally spy upon each other. So that makes it slightly awkward to say that European countries are doing perfectly well because they respect European data protection laws, but other countries do not, even though, yes, they do spy on each other as well. But that is still a baseline, the national security safeguards, that is still a baseline that the European Union wants to maintain. I think I'd better wrap up here because I've already spoken a long time. So, but that's more or less the background between why the Privacy Shield was so important, much as the Safe Harbor was before it, why the Schrems 2 decision is so important, what the big challenge is right now, why it's important to find a new challenge, but also, again, what the broader policy context is. It's international free flows of data are under stress, to say the least, and it's not certain yet how that will be fixed in the future. I think that's sort of the introduction that I wanted to provide there.
Thanks, Hans. Yes, so many thanks for this very complete introduction, and I'm hearing myself, so I'm muting here. So many thanks for this very complete overview and introduction, and you actually answered perfectly during your intervention to the two questions that were in the chat. Maybe before leaving Dan introduce the US vision, a very, very short question. I want to leave time to everyone to interrupt, but I think it's very important for the people attending this kind of event. So, for in your view, for the researchers and innovators on internet-related technologies, so what are the next steps you foresee for these kind of stakeholders now trying to collaborate with US counterpart? what are the key steps to take to continue the collaboration despite it's unfortunate event?
Can you hear me?
Yes, we can.
Great. And so a pleasure to join you. Thanks for including me. Let me know if there's an echo, but it seems to have gone away. So let me just real quickly try to sort of set the stage for Schrems 2, and then we can get into a discussion. The Schrems 2 decisions, the latest and perhaps so I'm going to try to sort of tackle this broadly, and then sort of thinking about how we can work at this in a transatlantic sense. So tackle it a little broadly in my opening, and then some specifics of the case, and then as we get into the Q&A, maybe some particulars about some of the things that we're working on in the U.S. And as was discussed, this is much larger than a privacy issue. This is really, I mean, the Schrems 2 decision is really much more about national security, and so that's the challenge. So the Schrems 2 decisions, the latest and perhaps most significant event in a long-running series of issues regarding the appropriate role of surveillance in our society and the inevitable collision of surveillance and privacy. So that's really what I want to get at. The decision, as we discussed, the decision invalidated the EU-US Privacy Shield, raised questions regarding the use of standard contractual clauses, created new obligations on data exporters at some level, and imposed certain obligations on data protection authorities. These findings have created uncertainty regarding transatlantic data flows specifically, as well as data transfers from the EU to certain other countries more broadly. And we could probably spend an hour on that, but the gist of the Schrems 2 decision is we're talking about it in a transatlantic sense, but the implications, I think, are much broader. The uncertainty is only heightened by the fact that this is the second time the CJEU has invalidated a data transfer mechanism with the U.S. So in the aftermath of the Schrems 2 decision by the Court of Justice, the future of data flows. So let me just step back and talk a little bit about Privacy Shield. The successor to Safe Harbor, and I've been doing this for 20 years. I was the chief privacy officer at the Department of Commerce and had responsibility for the then Safe Harbor rounds in the mid 2000s, and was actually at the Federal Trade Commission when we pieced the original Safe Harbor agreement together in 2000. And so in the U.S., so this is not insignificant. There are more than 5,300 companies that relied on the EU-US Privacy Shield, and so so there's obviously some very large companies, but of the 5,300, most are small and medium-sized enterprises, and so they're scrambling to find a basis under EU law for transferring personal data. And so since the decision on July 16th, I mean, the Commerce Department and the European Commission, I mean, have both put out press releases and have committed to try to work together. But we've got to establish a lasting foundation for data transfers in transatlantic commerce, addressing the core fundamental rights expressed by the CJEU. In particular, this would require making some provision for meaningful individual redress when the government obtains personal data by means of surveillance. In essence, what the CJEU did was, I mean, it repeated the legal standard developed in the 2015 Schrems 1 judgment with the privacy protections and nations receiving data from the EU must be essentially equivalent, which we've already talked about, to those afforded within the EU. Companies may satisfy this standard if they apply the same safeguards both within the EU and a third country. But specifically, the CJEU observed that, and this is where I want to get into some of the particulars, that the U.S. surveillance program conducted under Section 702, that's our Foreign Intelligence Service Act, or Executive Order 12333, do not grant surveilled persons actionable, and this is the key part of the Schrems 2 decision, do not grant surveilled persons actionable rights of redress before independent and impartial court. So all of the work that we did around in the review of the updating of Safe Harbor and Privacy Shield, the Ombudsman, the role of the Privacy and Civil Liberties Oversight Board, that the court emphasized that the existence of effective judicial review designed to ensure compliance with EU law is inherent in the existing rule of law, so that the Ombudsman and the P-Club and all of the visibility is not enough. The CJEU also identified two ways in which U.S. surveillance law lacks essential equivalence to EU safeguards. The first and the focus is that the lack of an effective and enforceable right of individual redress. And the second, which is beyond the scope that we're really going to talk about, is the issue of proportionality. So I just mentioned that because that was a highlight. So obviously, as was discussed, there's been a very strong reaction to this in the U.S. And that the CJEU insisting on measuring U.S. surveillance law protections against what some have described as an idealized formal standard set forth primarily in EU constitutional law. Actually, in practice, an EU member state's own national security agency need not meet the standard because the union's governing treaties state that national security remains the sole responsibility of each member state. So I mentioned that I don't want to get hung up on it, but I mean there's a lot of discussion about, since we're talking transatlantic, there's a lot of discussion about that in the here in the U.S. I think the purpose of our conversation today is to try to figure out how we can move forward, since both sides have a strong motivation to pursue a further agreement. And so I know, and we can get into this in the Q&A, of some things that the U.S. Department of Commerce has actually just done today. They've just issued a white paper on for companies looking to transfer or practical steps. It's an excellent addition to the conversation. But we've got a lot of work to do, and the transatlantic relationship is the most important trading relationship in the world, and so it behooves all of us to try to figure out a way to work this out. So with that, I'll pause, and then we can get into the discussion and take some questions. So thank you.
Thank you, Dan. I don't know.
Thank you, Dan. Can you hear me?
Yes, Dan?
Yes.
Okay. Well, thank you for this very quick overview. So maybe so that to go a bit beyond that. So what do you think are the next steps the FTC is what do you think the FTC will do in the near future on that topic before going back to Hans on the EU side and what has to say? And how do you think, Dan, how the US firms in GAFAs, of course, what will be their next move, basically, from your point of view?
It's getting quite an echo, but I think I heard the first part of the question, so I'll take the first part, and then maybe you can repeat the second part. For the first part, I think because you mentioned my FTC background before I joined the Department of Commerce. So in the U.S., Privacy Shield, the obligations that those 5,300 member companies took under Privacy Shield, those are still enforceable. I mean, as a commercial arrangement. So as it works in the U.S., the Department of Commerce is responsible for a Privacy Shield, but the Federal Trade Commission is the enforcing agency, and so the FTC, and the Commerce Department have continued. I mean, they've both stressed the importance of continuing to enforce the obligations under the Safe Harbor Agreement, and I know the FTC, will is brought a of Privacy Shield cases, and will continue to do that. One of the very positive things, and there's a lot of good that's come out of the revision from Safe Harbor to Privacy Shield back in 2015, is that on the U.S. in the U.S. government side, it's become much more of a whole of government approach, and that of course is led by the Commerce Department. But in terms that also includes, all the because of the concerns that were raised in the original Schrems decision, national security, Director of National Intelligence, obviously the Department of Justice, the Department of State, Department of Commerce. And so the work that the groundwork, I think, that's been laid in the U.S. in the review of the Privacy Shield gives us some hope or some cause for optimism that we can reach. The agreement that needs to be reached really is a narrow. It's a national security agreement, and there've been a number of successes over the years in the transatlantic relationship with. The passenger name, and none of these have been easy, but we do have some work to build on. So the passenger name record agreement, the Treasury agreement over SWIFT, which caused some consternation years ago, and then the work that was actually adjunct to the Privacy Shield around the high-level working group, which led to judicial redress for EU citizens in the U.S., but what's also known as the Umbrella Agreement, which is really more criminal law enforcement. So we have some remedies or some actions for success, but threading the needle in terms of national security is kind of that's the hardest thing that we're going to have to grapple with here in the U.S.
Thank you. Threading the needle, indeed. That's quite a challenge. In the meantime, so as I'm actually asking you, Hans Graux, about before we come up with new solution, which is still the case, what do you think are the key steps EU researchers, innovators, so NGI community, who's here already trying to cooperate and already cooperating actually with US stakeholders, what should these communities do in the next steps of the collaboration?
Well, I think there's two.
Sorry. This question is actually for Hans. Graux.
No, so I think there's the formal part and the sort of substantive part. Formally, researchers that used to rely, for whatever reasons, on Privacy Shield now need to rely on the only other mechanism that they have available, standard contractual clauses, if they want to continue to transfer data to the United States. So that's just a practical point that they need to look at. The second part is the more substantive part, which is looking at whether there are adequate safeguards for personal data that they would be sending to the United States. The main thing that they can do there is indeed to screen what the risks are in practice for their data to be intercepted and what they can do to mitigate those risks. Not every transfer is particularly risky. I've had, just to give it's a trivial example, but it's relevant. I had someone on the phone last week basically asking whether they could still have Zoom meetings on the basis of standard contractual clauses for public-facing workshops. Of course, that is not something that's supposed to be controversial. They're public-facing workshops. People register for them and can join in at any time. The fact that you're using a US-based service provider for that is not a particularly big thing. The bigger challenge becomes that you have to assess on a case-by-case basis what kind of data you would be sending outside of the European Union and whether there are particular risks for fundamental rights under applicable data protection law. I think this is in practice for most organizations, for most research organizations. It'll be mainly relevant for them to understand whether they would be sending unencrypted data to a service provider at a relatively large scale containing sensitive information. There are other workarounds that have been suggested to mitigate the risks, which is in terms of implementing additional contractual safeguards, Issues like not voluntarily cooperating with law enforcement requests. But in practice, these are all but useless. These are things that do solutions, because the fundamental conflict that we have is between the safeguards that European data protection law is expected to have versus competences that apply in other countries. So for most research projects, for most research organizations, the short-term solution that they have is assessing which kind of data transfer activities they are engaged in, assessing which kind of specific risks that they run for those data processing activities, and seeing whether they have alternatives that are easily available for them, either through technical measures to mitigate the risks by scaling down the amount of data being transferred, or by looking for alternative providers. None of that is an ideal situation. None of that is particularly sustainable. And all of it, I think, is harmful in terms of societal progress. But in the short term, when you look at what an individual research organization might be capable of doing, I think those are sort of the only practical recourses that they have. Everything else is much more complicated, is much more bigger picture. It's much more about the broader policy perspective. And that's not something that a European research project can reasonably hope to influence.
So let me take that from the U.S. side. I think there's two things that need to happen on the European side. Well, one thing on the let me give one thing on the European side, one thing that's optimistic on the U.S. side. So on the European side, and we've had a good discussion about the importance of standard contractual clauses. I think it was in early September, maybe during the Libe committee hearing, the European Data Protection Board, EDPB, has formed two different task forces to look at ways to revise and update standard contractual clauses. So that's going to be important in terms of enhancing trust and confidence. And the European Commission, in this case DG Justice, is also working, specifically on and no exact timetable, but I know that the midnight oil is being burned to work on revising standard contractual clauses, and then work across the Commission and also the coordinate among the DPAs and the member states. So that's important, and it's positive. The other, and I mentioned it, and it's actually hot off the press. It's just this morning from the U.S. Department of Commerce has issued a white paper about specific to the issue of transferring data between the EU and the U.S. And it's as has been discussed, it is cumbersome, and it is you have to do a case by case analysis. But part of the analysis is are you transfer? So for instance, the example of the Zoom call, is the data that you're being transferred, is it likely or not to be part of a national security letter request or under surveillance law in the U.S.? If not, then it becomes a much easier calculation. If it is, then and so that's that becomes, like I said, much more time consuming. But I would commend the U.S. Department of Commerce white paper that was issued by Jim Sullivan, who's been responsible or is responsible for Privacy Shield, as a very substantive. It's very, very legal in nature, but it's very precise in terms of what organizations need to do to look at to be transferring data from the EU to the US.
Thank you. And I can see. So very quick question. Well, it's a interesting question from Marking about the fact that there are many bias. I mean, there are many ways this adequacy requirement can take, notably the Tongan domain. So what? Maybe.
I actually did. It's kind of facetious, I know, but I looked it up, and the service provider is actually hosted in the UK. So this is actually not maybe an issue right now, but once, assuming that we get a no-deal Brexit, then there actually is again an adequacy decision issue to be had, which is really that it's verging on the silly. Let's stick to that. But the fact that it's using a Tongan domain name, it does point to a UK-based service provider.
It's adding to the fun. Yeah.
That can be our next panel.
No, but there's actually, if I might, there's an interesting question that was just posted in the chat. So, like we mentioned, I think part of it is indeed the likelihood of, is this data actually reasonably likely to be targeted by these kinds of letters, these kinds of orders? Basically, is this the enemy that I should be worried about? Which for a lot of organizations and for a lot of activities, the answer is no. US national security competences is not the big issue that you should be worried about. In those cases, I think it's easier to justify that, yes, standard contractual clauses still provide you with appropriate safeguards, taking into account the nature of your activities and the nature of the risk. The other thing, at least in the short run, and that's the question that was posted here right now, is what about technology? What about anonymization techniques? Does that help? The answer is yes, it can. Yes, it will. Anonymization is part of the answer. Encryption can be part of the answer. The problem that we have right now is all of this is very use case specific. And if anybody wants to make the answer simpler than, yes, it can help, but you need to look into the individual case, then they're oversimplifying and they're just not telling you the truth. That's the fact of the matter. In a lot of cases, encryption is perfectly possible and perfectly appropriate as a safeguard. For many cases, anonymization techniques as well. If you anonymize perfectly effectively, data protection law is not even a concern anymore, so that resolves the issue. But we also need to factor into the possibility of re-identifying anonymous data and the possibility of combining supposedly anonymous data and turning it into personal data again, which again, the more sensitive your data becomes, the higher the bar, the higher the standard that you will be held to there as well. So anonymization techniques and encryption techniques are definitely part of the answers and part of the additional safeguards that you can implement to justify transfers. They're just not silver bullets. At least that's something I might be hoping.
Well, and that also speaks to the need in the U.S. for a comprehensive federal privacy law, which, of course, we're all well aware, painfully aware, we don't have one in the U.S. We've been working on this for 20 years. And so some of those issues of data collection, anonymization, encryption, I mean, those presumably would be covered in a comprehensive federal privacy bill. So on that score, I'm actually optimistic because there's been more progress made on federal privacy legislation in the last 2 years, I believe, really, than in the last 20. And so while a federal privacy law in the U.S. is not going to solve the national security implications of SHRIMS 2, it will get us, closer, to I mean, it's going to look different than GDPR, but in terms of valuing privacy the way that it's a strategic priority in the EU. So even though we have a presidential election here in the next 6 weeks in the U.S., I fully expect that privacy and the issue of data will continue to be a high priority in the next Congress, and I hope that by doing that will move us closer. Again, it's not going to be exactly like GDPR or the California the CCPA of legislation, which is taking effect. But I think we're talking in the U.S. about having a higher baseline for privacy and for data. And for that, I mean, we can all be thankful.
I think there's a horizontal awareness on both sides of the ocean of the importance of data. And I think the Californian data protection legislation on that front could be very promising, but also, and that's to me a stranger trend, but it does seem to be correct. From the United States, both sides of the political aisle, there seems to be a conviction that perhaps some ICT companies would benefit from having their activities more systematically regulated. Not necessarily in a GDPR model, but that can be one of the pieces of the puzzle that can make the United States and the European Union more aware that there's similarities in the perceptions of the importance of data, and also what national security services are supposed to be capable of doing. Just, we talk a lot about the differences in perception of data protection, but one of the comments in the chat pointed it out already. European member states have their own national security legislation. They just benefit from the fact that it's not harmonized and not as visible as the legislation that you have in the United States. I'm not optimistic on approximations between those national laws, but I think it should be possible at least to see eye to eye better on that balance between having stricter data protection safeguards and still allowing national security organizations to do their jobs. A lot is moving there on both sides of the ocean, so I'm still optimistic on the possibility of a successor to the Privacy Shield.
Thank you for that. Actually, the echo is quite incredible. Okay, let me mute here. I actually have the €1 million or dollar question. You shared and explained very well that so for the time being, in terms of research, the next steps will be a lot of paperwork, and unfortunately, even if research and development communities do get good solution, good alternatives in terms of anonymization or any kind of technology that can, let's say, bypass these kind of issues between the EU and US, there will still be a lot of paperwork doing. But the €1 million dollar question is, how long will it take? To your point of view, I mean, what do you think is a reasonable timeline for developing? I mean, you think the agencies and policymaker will take for actually achieving to create a new, better, improved framework for this kind of cooperation in next, let's say, months, years? So what do you think is a reasonable timeline for a safe, let's say, exchange framework?
Well, I'll kick off. I'm optimistic that we can get a new agreement, but it's hard to kind of. It's a great question, but it's hard to put it in a specific timeline. I mean, and part of that is, like I mentioned earlier, I mean, we have an election here in the U.S. in 5 weeks, and so depending on the outcome of the election, if we have a change of administration, that's going to slow that. I think there's a bipartisan consensus about the importance of this. I mean, the changes to Privacy Shield occurred in the Obama administration, and the Secretary of Commerce, Penny Pritzker, at the time, I mean, made this a personal priority. I mean, Secretary Ross, at Commerce now, this is one of his highest priorities. So there's no question that if we have a new administration in the U.S., that it will be a high strategic priority. But you've got the issue of new people coming in, and the time that it takes to get senior level people in place. If we don't have a change of administration, then I think it probably it has a chance to move a little more quickly. But as I said, the national security implications, particularly of surveillance in Section 702, I mean, I agree that I mean, the point was made that we have lots of cooperation on national security and law enforcement. I mean, with the EU and with with member states and with the rest of the world, but changing those authorities and asking whether it's the US or the EU to give up intelligence gathering, that's a very very difficult proposition. So I'm optimistic that we'll get it done. I'm just not. I'm not really able to offer a particular timeline, mostly because of the upcoming elections.
Yeah, I think to just add a couple of small thoughts to that. So I think the timeline is indeed unpredictable. I think the Privacy Shield went reasonably fast but I think that's also because the decision from the Court of Justice at that point was expected, and discussions were already ongoing on the Privacy Shield before the safe harbor was invalidated. So that expedited matters a little bit. I think I don't have any internal information, but I don't have the impression that discussions here had already been ongoing on a successor to the Privacy Shield. So I'm less optimistic about things progressing more quickly. I think what might happen much more quickly, and what would possibly be useful to organizations already, is more of a formalization, recommendations, guidelines on those additional measures, on those additional safeguards. If you look at the white paper, for instance, on this topic, apparently the United States has moved more quickly than the European Union has. I think if you have that white paper, I think if the European Data Protection Board could produce something similar on its own expectations, and companies could merge those, put those two together and say, well, these are the terms under which I could work with standard contractual clauses right now under existing legislation and existing policies right now. That is something that could happen within the next couple of months. That could be done and should be done relatively quickly. And I know a lot of data protection authorities in Europe are already working on that, which is not hugely good news, because that means they're going to be doing their unique national thing. So I do hope that they put their knowledge together and come up with a joint position there. And that would also, I think, provide some inputs to a future policy initiative to a Privacy Shield 2. But that will take a longer period of time. Also because, indeed, like Dan says, the fundamental issue does not go away. We are not going to be able to come to a policy that ensures that European data cannot be made subject to national security requests unless European authorities are aware of it, or whatever other kinds of framework that you would build around that. So I'm more optimistic about let's say a smaller revision to the Privacy Shield that already gives some guidance on those safeguards that should be available, possibly also with a stronger recourse mechanism. But that, however, I don't think will fix the issue permanently. I think we will have at least one more interim step before we get to a more mature and more permanent solution. I think that's just the way the situation is likely to evolve right now.
Okay, thank you, Hans and Dan, for your sharp comments. And well, so fact is that I won't give $1 million or euros to anyone, since from your intervention it's pretty clear that there are a lot of steps to do before actually foreseeing a new or renewed, and I mean, I'll say, if we want a new or renewed framework between the EU and US that doesn't go through each EU government, and with a new also government in the US side with well, Biden or else. So then, Hans, many thanks for your intervention. Many thanks for your very interesting entries. And yeah, well, thank you really for this. We'll share a white paper to everyone and everything following this session. And yeah, well, thank you again.